Let me start off by thanking the Alberta Law Enforcement Review Board for the work they did in the Arkinstall Inquiry, which brings us here today for their released report, which outlines the board's findings on how the Calgary Police Service addressed allegations, which have since been disproved, that 2 officers assaulted a man during an arrest in 2008 and then provided false testimony during the subsequent trial in 2010, with a written decision coming in 2011. The review found there was no evidence of any deliberate attempt to avoid, impede, frustrate, or interfere with the disciplinary process. The subsequent report, however, identifies numerous ways the service failed to properly investigate and address these allegations when they were raised in 2011. While this was not intentional, we clearly fell short of public's expectations of how we investigate and address members' conduct in this case. This was a failure of the service as a whole, and for that we apologize. Accountability is one of our core values, and we know that a thorough and transparent process for addressing citizen complaints is critical to maintaining public trust. The service takes the findings of the Arkinstall Inquiry very seriously and accepts the recommendations made by the Law Enforcement Review Board relating to the Calgary Police Service. We've already taken many steps to improve the policies and procedures that led to the mishandling of the investigation into the Arkinstall case. However, there is still work to be done, and we are committed to continuing this work until all issues identified in this report are addressed. So to date, the service has taken several steps to address the concerns, and I'll go through a couple of them. The policies and procedures for administrative reviews have been reviewed and updated to create more rigor around documentation, note-taking, and chain of command. The service is also creating policy for when these reviews are and are not appropriate. The policy around 46.1 notifications has been clarified to ensure the province is being notified of sensitive matters whether there is a complaint or not. The process around initiating service investigations are being reviewed. More clarity is being added around what constitutes a complaint under the Police Act and what the service will do when a court or Crown prosecutor expresses concerns about officer conduct. The service has rewritten the online information provided to citizens to explain the complaints process in clear, easy to understand terms. That was done last year. We have also published annual reports that help improve transparency of the process. The service is working closely with other agencies and the province to also look at Police Act reform. This will help provide stronger oversight and more effective process for investigations into police conduct. We will be working closely in the next few months reviewing the other recommendations in the report, and will be working to address the issues raised in each one, and will be reporting progress to the Calgary Police Commission. I will now take any questions that you may have.
So the charges were dropped against the officers in the case in both matters, the perjury and the assault, correct, right?
One officer had his charges acquitted at trial, and the others were dropped.
Okay. So then in terms of what went wrong in the investigation, what were sort of the mistakes made in terms of record keeping and that sort of effect?
So one of the things that we had talked about is that I don't want to get confused is when a complaint comes into the Calgary Police Service, the steps that we take to investigate that. And so clearly any complaint that comes in under the Police Act needs to be investigated thoroughly. The facts as are uncovered during that investigation are then reviewed to determine whether there constitutes an offense either under federal statutes or criminal offense or under the Police Act. And if there is, then charges are appropriately laid and the due process takes its course in a criminal proceeding through the courts and an internal proceeding through a hearing if it's determined to be a serious matter. If it's not a serious matter, there are a number of alternatives that are open under Section 19 of the Police Act, which would allow for anything from written warning up to 80 hours suspension without pay, which is a significant penalty. There's also counseling that's available under Section 6, And if a complaint is deemed to have no merit, then it's obviously dismissed.
So could this whole process have been settled much earlier if these things were taken properly?
I'm always careful to not look at things in hindsight, but we're talking 10 years after an incident, and sort of 2011 when it came to our attention. My view is, and the view of the organization, is that all matters should be viewed, investigated thoroughly, and that allows these things to have a timely resolution to it.
These policy changes that you've already implemented, when did you start doing that?
The policy changes have been ongoing, and you'll see that they're going to be ongoing in the future. We've just conducted a strategic planning at the beginning of 2018, and we're mapping out the next 3 to 4 years of work in professional standards. But many of the ones that I've talked to you about really were ushered in with retired Deputy Stuke, who took over the professional standards section in 2015.
Were they in response to the Arkinstall case, or?
So we were aware of the Arkinstall matter, and in the report it clearly outlines a number of things around decision making, the 46-1 that didn't flow in the manner in which we would like to see them, or I think anyone would like to see them, and we've been making those changes in an ongoing basis since that time. So 2014 was the ACERT investigation. 2015 we're commencing some of these policy changes.
So in this report, it's saying that, you know, the investigation that you guys did, there was some mishandling of the investigation, but it wasn't intentional. Was it not intentional just because, like, the structure wasn't there or the policies weren't there, or was it human error or something like that? How was it not intentional?
Yeah, so few things. The intake process, if you look at the majority of complaints that come in, it's between an officer interacting with a member of the public, and within 6 months they're phoning professional standards and making a complaint. And oftentimes that phone call will come in and they'll just tell what their account of the incident is, and our investigators will actually help them to go and navigate the Police Act in order to be able to actually formalize a complaint process. This one, as you see, is taken a very, very different route, and because I'll call it, it's a rare occasion, it wasn't handled in a way that was as tight as the majority of our complaint process is.
You're saying because of the passage of time between when it happened and when it was?
Well, so 2008, an incident happens, right? 2010, there's a trial and a court decision where there's comments that are made from the judge that the Calgary Police Service are not aware of for another 6 months. We're made aware of that. We take some steps to look at trying to find out what happened in that investigation. There's some exchanges best outlined in the Arkinstall report to see where that went back and forth to determine, you know, is a complaint being made, was there misconduct? And the best way to get to the bottom of that is an investigation, and clearly we see that in 2018, looking back over the years.
Before those policies and procedures were updated for an administrative review, what did an administrative review look like? Was it too informal? Is that kind of what the Law Enforcement Review Board is saying? Or was it a formal investigation, or what did it look like?
So the best way to describe administrative review is it's for organizational learning, and so that there is not a complaint, or so it was never designed to be a substitute for a complaint process. It's to look at an incident, say for example the 2013 floods. You could do an administrative review around that function and to see if there's things that we could do better. In that process, there would always be off-ramps that if during the discovery of an event you're finding misconduct, then that would then be rechanneled into a police service investigation. The challenge was we didn't have that documented in a way that clearly delineated the boundaries of what a administrative review does or does not do. That has been subsequently addressed.
Sorry, one final question. In your initial statement, you said that this was a failure of the service as a whole, and you apologize. Why was it important to apologize?
Well, we police by consent, and that consent is from public trust. The public expect that we follow due process, not that we look at ends justify the means. It's that we're actually following the process in a way that justice is not only done, it's seen to be done. And in this case here, there were a lot of questions around that would cause the public to have some questions, rightfully so, and we should be above that.
Okay, thank you very much.
Great. Thank you very much for your time.